Hello, Jessica. Hello, everyone. Jess, I thank you for everyone joining us today. I think, shall start. It is 2 p.m., so we won't make people who made it on time wait for others. And others will be able to join while we speak. So, hello, I'm Maria Primushko, the founder of MVP Law Group, a professional corporation from the beautiful city of Encino. One little fact that nobody or very few people know about me is that since seventh grade, I knew that I was destined to become an attorney because of my strong conviction to protect people. And I focused my practice on assisting families since 2009. Well, during my practice, I found that what parents mostly worry about is the following. First and foremost, they want to make sure that their children will not end up in foster care system. That is one of the most important concerns each and every parent has or should have. Then they want to avoid all unnecessary expensive, such as attorney's fees, court fees, unnecessary delays in passing out their assets. Also, we have to be concerned about living probate. We'll touch base on that later on. Death probate, death taxes, victimization of your surviving spouse and children by predators, creditors, divorcing spouses, and possible remarriage of your surviving spouse. We want to make sure that your kids, original kids from the marriage, are protected. And money is important. Assets are important. We want to protect our children financially. But one of the most important things that often overlooked in estate planning for younger families and other families is failure to pass on wisdom and values and allowing your lifelong principles and your core and your experience to die with you instead of passing on with your children, grandchildren, and so on. So that's what we're trying to avoid. So this presentation will focus primarily on these issues. We want to protect your children financially. We want to make sure we have right people and resources to care for them, for their nurture and care. And also we want to make sure that they inherit your personal wisdom and values that you have. Not each and every person who joined us here today and who will listen for this presentation in the future will have assets. Some of you may think, oh, I have nothing. I have just my child. I'm a single parent. Please be aware, these principles apply to everyone. Either you're a single parent with no assets, or you're a full, complete family, or your blended family. These principles apply to all. Or if you have any special circumstance or specific situation, I'll be happy to assist you during our personal consultation if you need one. So let's proceed. We're going to discuss today some very important issues. So I wanted to introduce myself a little more. My name is Maria Primushko, and I'm founder of MVP Law Group, a professional corporation located here locally in Encino, Greater Los Angeles area, although we serve the whole state of California. I received my bachelor's degree from St. Petersburg State University back in Russia. Probably you can tell from my accent. And after becoming an attorney in Russia, I worked for some time at St. Petersburg District Attorney's Office. When I came here to the United States, I had to go to law school again. That's another known fact about me. And I graduated with Juris Doctor's degree from University of West Los Angeles School of Law. And before taking my bar exam, state bar exam, which I passed from the first try, I interned at Los Angeles City Attorney's Office. And throughout my career, I chose practices where I could help, protect, and advise clients and families to organize their affairs and lives without any interference from any government or other agencies. And also, I'm a mother, I'm a daughter, I'm a business owner, and I'm a pet owner. So I know how it's important to protect your family, your assets, and to have peace of mind about your children and about your future. I see value in hard work, especially being an immigrant and going through all way of the immigrant life, starting as a babysitter and housekeeper to having my own practice. And this hard work should never be wasted, trivialized, or lost to any government or system, but should be guarded for your future legacy and family. After working at the district attorney's office back in St. Petersburg, and then here at the city attorney's office in Los Angeles, I ultimately realized that it doesn't matter which continent or country you live in, the system is the system. And as soon as you're placed in the gears of this system, it will eat you. It will drag you through all kinds of hoops and potentially can be a disaster. Remember, if you don't have a plan, it is also a plan. The government has it for you. It has to be cleaned out, which is why I ensure that no government agency has any say in what you want to do with your life, your children, your assets, and your wealth. So, what is estate planning? For many, estate planning is about making arrangement for your death. However, estate planning is about much more. In the midst of pandemic, especially now more than ever, it's important to plan for a time when you may still be alive, but unable to take care of yourself or your minor child. This inability to make decisions or care for minor child is sometimes referred to as incapacity. And please keep in mind, what last year taught us, that life is unpredictable. It can take an ugly turn at any time. One day your child goes to school and happy, you have employment, you have thoughts about and projections about your future. Next day, your child sits at home, looks at the iPad, a computer, and studies remotely. Many had to lose or quit their jobs to accommodate their child's education. And unfortunately, many of us lost our loved ones, or at least had a really bad scare about their health. I personally lost 3 close people for the past 6 months. It's been hard. And now, more than ever, we have to make sure that our children and our future and our assets are protected, and we have a say on what's going to happen with it, not somebody else. So proper estate planning will help us answer these important questions. What if I cannot manage my finances? Who is going to take care of me or my minor child? Another one, what if I cannot physically care for my child? What is going to happen to my child? Remember, we noticed that if there is no planning in case of disability or death, the court will step in and take matters in their own hands. And as a result, you don't know who's going to be appointed as a guardian or the conservator for you to manage care for your child or finances for you and your child. There are 2 types of probate that we need to know about. I'm giving you now general knowledge. It is related, believe me, it is related and very important. And unfortunately, very few people know about it. I receive calls every day when it's too late. And it's so sorry to hear when it's too late and I cannot help. And the only way for us to go to court. Going to court, it's never a good idea. Let's take a look at the living probate. Living probate is the court proceeding to name your conservator or guardian to look after things should you become incapacitated. Our audience today are most likely younger people. So we're not talking about right now possible Alzheimer, or Parkinson's disease. These are issues that I discuss with my older clientele. For this, for our crowd, for us young people with minor children, it is important to remember that life is unpredictable. There are car accidents, there are health issues, there are strokes, so there are illnesses, unfortunately, and we have to make sure we have the answer to these what if questions in our life. So let's say something happens, car accident or illness. You're severely disabled, but you live for another 10, 15, 20, 30 years, who knows? And throughout this period, you're not able to handle your financial and legal affairs. And remember, if you have no plan, that could be a person or family member that you don't like or you don't trust. That could be that evil aunt or sister or cousin who petitions the court to become your conservator. And if nobody else stepped in, the court will appoint them. And that person will handle your finances, will handle your care, and will potentially handle your child's care. So it is so important to make decisions yourself, to appoint the person that you trust, that you know, and of course appoint somebody else to be to oversee your appointee's actions. And very important that it's public, expensive, and humiliating process. Basically, person has to be brought into court where he or she will be stripped of their rights to make their own decisions. It is so unfortunate to see these procedures. So what I'm trying to do is to give power to you guys to make sure you appoint the right person for you and your children. Then we go to the death probate in case somebody dies, a parent dies. Death probate's main purpose is to change the title of property that you own. If you pass away and your family wants to spend or sell an asset or refinance or lease an asset in your name, they can do that until the court signs off and transfers title to their name. If there are minor children involved, they will have to wait for a long period of time before they can receive the benefits. And please keep in mind that in California, children do not have automatic right to the inheritance. So potentially surviving spouse will get the chunk of the money. So it's so important to plan, to have the right planning, including life insurance, especially for single parents or parents with limited assets. Life insurance doesn't cost a lot when you're young, and it is so important for you to make sure that your kids are protected for the future. Something happens to you, you know that they will still have resources for their education, for their food, for their shelter, for their medical attention. And you don't have to rely just on somebody who will step in as guardian or the government system. So, and anytime we're talking about exposure to courts, it is expensive. 25 to 35% out of all estate will be spent on all kinds of fees: attorney's fees, filing fees, court fees, appraisers, accountants, court-appointed guardians, court-appointed accountants, you name it. And all those money will be paid out of the estate. The money that were intended, I'm sure they're intended for the use of your children or your use while you're living. Finally, if you own any real estate or any assets of more than a certain amount in any other state in the United States, another probate proceedings will have to be open in each particular state. And that escalates the amount of money you'll have to pay, or your beneficiaries will have to pay eventually. Also, having just a will in place will ensure that your estate will go through the legal process of death probate. Will is a good option only when there is no estate, when there is no real estate or no any major assets, and we'll talk about it shortly. So let's take a look at ways to protect the financial needs of you and your minor child. So we will talk about financial and we'll talk about actual care growing up. So, revocable living trust. I'm sure many of you heard about this term, but very few people know about it and actually understand what it is. Revocable living trust enables you to name yourself as a trustee. Basically, you will occupy three positions. As a trustor, person who created the trust; trustee, person who manages the trust while you're living and healthy and happy; and a beneficiary, because it's called living trust. It lives with you and it's effective while you're living. So nothing changes besides the fact that you will transfer everything that you own from your own name into the name of the living trust. And that way, and in that document, in that basically contract, you, as Jane, for example, will appoint Jane the trustee to manage your current assets. And you will put the terms. If I become disabled, I appoint this person to be in charge of finances. I appoint this person to be a guardian for my child. And you'll appoint successor trustees as well to make sure it's consecutive and at no point court interference is required. That way you will know exactly now at the time of signing what will happen in case you become disabled, what will happen in case you pass away. Also, as I mentioned, co-trustee position is very important if you're sick right now. For example, you're ill and you're not able to walk. You can appoint a co-trustee right now while you're living, your mind is clear, but that person will be able to step in on your behalf and act on your behalf, and you can give instructions to them. Then, when we create a living trust, how the accounts should be, everything that you own, how should be treated in that living trust. Part of what makes trust an attractive tool for parents is the ability to customize exactly what happens with the accounts and property that are transferred into the name of the trust. So the trust basically becomes your treasure chest. Whatever you own, the Jane person, she will sign off all the rights into the name of the trust. And that way, if something happens to her, there's going to be no court interference, because everything, all the rules and terms are in that treasure chest. And whoever steps in as a co-trustee will read it and will have it to administer it accordingly. If you're alive but unable to manage the trust, the money and property in the trust will still be needed for your care. So you act as a beneficiary, you do everything in your own interest and interest of your loved ones, of course. However, you might also want to ensure that your minor child continues to be cared for in some way should you become incapacitated. So if you're sick, we're gonna write a specific wording in the trust. Yes, I'm sick. You have to provide care for me, medical, health, housing, etc. But also we allocate this amount of money for the care of my child. We'll have a guardian there, so they will step in, care for a child, and use the money that you've allocated, even if you're incapacitated. However, at your death, you will no longer need that care. So a greater attention will be placed on providing for your minor's child benefit. Remember, if there is no plan, either during incapacity or death, the court will step in, and we don't know who will they appoint as your conservators as caregivers for your child, and who will take care of finances. Remember, we all have that family member that we don't trust. And from my experience, it is very often that they are the ones who step in and petition the court saying, hey, I'm going to be in charge here. I love them all. Although there's going to be a court supervision, but still, you don't want your children to be in any danger of any foul play or bad faith, because sometimes even good people have to make wrong decisions because of their own personal situation. So we want to avoid that. And we'll have in our trust document, we can appoint a caregiver for your child and a person who is responsible for finances to at least two separate people. Also, we can have appointed kind of a referee or trust protector who can supervise all of them to make sure that none of them uses money inappropriately or does bad care about your kids. Very important. So hopefully you're following, right? Okay, then we are moving to when our kids gonna grow or become adults. So while they're minors, we're creating trust for now, kind of insurance. So with these trust documents, we make sure we foresee all kinds of situations. If we become incapacitated or we die, and we have set of rules, what's going to happen next. When they reach the age of 18, theoretically, well, actually legally, they become adults, but we all know that it's the worst age, probably being 18 years old, and even 18 years old will agree with me for that. And no two children are exactly the same. I have 3 children of my own, and they're all different. So there could be good kids, broad term, and there could be bad kids. Of course, they're good to you, but they may have some problems. It could be addiction, unfortunately, the life we're living right now. It could be gambling, it could be drugs, it could be just they're subject to, they get under someone else's influence too easily. And you know that, and you foresee that. So if that child at the age of 18 years old receives an inheritance of whatever, 200,000, 1 million, you know that it's gonna be spent fast and not for the right cause. And you want to avoid it. For that reason, we can set up special ways how we devise that money to your children. For example, we can give percentages at a certain age. For example, 10% they can receive of the principal. They're still going to be cared for. Trustee will make sure that they have a roof over their head, they have food, they have medical support, the education expenses covered. Of course, it depends on the assets that you own and that they will be able to use. But let's say at the age of 21, they can receive 10% of the principal. For example, they can purchase a car or spend for vacation, if you allow that, or get their first apartment or pay rent. Then at the age of 25, they can receive 20%. For example, they finished their education and they want to open their business or purchase a house or get a wedding. It's all good causes, right? And let's say at the age of 30, they get the rest of the inheritance. If there is no inheritance, remember we talked about it, we at least have to make sure we have life insurance. So important, ladies and gentlemen. It is crucial. So we do not leave your child with nothing. Okay. So these are percentages. Then we can have incentive trusts. That means that, let's say you know that your child is kind of it's not very good with education and says, oh, I'm not going to college. So you can incentivize them. You say, hey, you get this amount when you finish college, or you can get, if you're sober for 6 months or 1 year, you get this amount. If you're employed for half a year, you get this amount. So it gives your child a power I want to cite, I had this client, this older lady, she had adult child, and she told me, okay, everything that I own, I'm giving to the charity. I'm not giving anything to my son. And of course, I ask very uncomfortable questions sometimes. And I asked her, so what happened? And she said, she's a drug addict. And I know if he received this money, he will possibly die or just spend it all, or overdose. And I don't want that. And she was crying. So when I suggested that we can create this incentive trust for her son, whereas if he's sober for 1 year, he received this money. She was so happy, and it actually gives her son power, getting back to life. Maybe he'll rethink his life, and maybe he'll go to rehab or get his life straight. At least mother now has hope that her son will get back to his feet, and if not, money will still go to charity. It's just an option. Then we can create a discretionary trust. Again, if we have a problem child, or we have a very smart child, but he or she might go into a career where lawsuits are possible, or she's 17 years old and the boys she's dating, giving you a hint what kind of husband she may end up with, and you already don't like that scenario. So we want to protect them as much as possible. So we create this discretionary trust where we appoint somebody else as a trustee for the trust. That way, your child is protected from predators even throughout their adult life. And predators and ex-spouses, because unfortunately, even if child is smart, educated, when they're married, if they receive inheritance, I see it all the time, if they receive inheritance in their own name, they go and deposit into their joint account and immediately commingling funds with their community property spouse. So next day, their spouse that you didn't like at all wants to divorce them, they have right to half of the inheritance. I'm sure that's not something that you've envisioned and not something that you worked all your life. So some guy who slept on the couch all the time while your girl was working, or the girl you haven't liked from the beginning, gets half of it. So something to consider. Very important. Another situation, you have special needs child. These people are dear to my heart. If there is a child with disabilities, current or possible future, you want to make sure you create a right drafted special needs trust. So when they turn 18, they're not stripped of government assistance programs, because if they receive inheritance in their own name and not in the name of the trust, government will come back and say, hey, you're rich now. You're not qualified for any of the assistance. So please think about it. Talk with people who who have special needs kids. It has to be very carefully planned for. So there's added benefit of a trustee. Because you choose the trustee and determine how the money is to be managed and spent, you can rest assured that former partners or undesirable family members will not have the ability to spend your minor's money for their own benefit, even if one were to end up raising your child. So we have that trustee who is responsible for financial control and spending for your child. Again, if you have this trust, it's one of the most attractive and popular reason for many people, not just parents, to choose a revocable living trust, is that the accounts or property that are properly transferred to that treasure chest, to this trust, will avoid going through the probate process. It could save your loved ones lots of time and money and keep prying eyes away from your family affairs. As we discussed before, probate process is public and expensive, and time consuming. Here in Los Angeles County, it takes about 2 years to probate the estate. And that's if everything's good and everybody loves each other, etc. If you remember, the most recent case is Larry King, famous Larry King, who passed without having living trust. Now all tabloids talk about it. It's in probate court, and we know everything what's going on, who gets what, how many kids, what the relationship, ex-spouses, etc. So we want to avoid that. Then another way, we're going to talk now about another ways to protect your, to manage your financial matters while you're incapacitated, is to make sure that you have an up-to-date financial power of attorney. This document allows you to name someone to manage account and property that you own, not the one in the trust. When this person can act, an amount and authority of this person will depend on the type of the financial power of attorney that you execute. There is an immediate financial power of attorney, and it becomes effective immediately. And although this person can act as soon as the document is signed, you're still able to handle your own financial matters. You just have another person who can act for you as well. For that, you have to trust that person very much. I mean, these immediate powers of attorney is usually created for older people who don't want to manage their affairs anymore, or who are sick, or for younger people who are ill, for example, bedridden, or can't go out, or or heading for the surgery, things like that. On another hand, there's also springing financial power of attorney. It's effective once you're unable to act for yourself. While this type of financial power of attorney ensures that someone can act for you when you cannot, it is sometimes difficult to get third parties such as banks or other institutions to accept the documents, because they have to provide evidence that you are actually incapacitated. So usually we have at least 2 doctors have to say that you're unable to take care of yourself. A general financial power of attorney allows your named person to handle any and all transactions that you would be able to engage in yourself. Alternatively, there is a limited financial power of attorney specifically lists transactions that you chose person to engage in. For example, you're out of town and you're unable to attend this final estate closing, and you have to sign a deed. So you can name that person for this particular reason. Lastly, it's very important that your financial power of attorney is durable. This means that the document remains in effect after it has been determined that you are incapacitated. This is incredibly important because, as discussed earlier, one of the reasons you are having an estate plan prepared is to protect you while you are incapacitated. Remember, financial power of attorney, that's the least you have to do. Now we're turning from financial issues to care. Remember from the beginning, what will happen to my child if I cannot care of them? Perhaps the most important consideration when planning for a minor child is who will raise the child, or who will temporarily care for the child if my client, or if you cannot right now. If your minor's child's other legal parent is still alive and able to care for them, their other parent will most likely step in and continue to care for the child, or will become a new day-to-day caretaker. In this case, it's still important to plan for what will happen if both of you are unable to care for minor child, if both of you pass away or just unable to care. However, if you are the only living parent, or if the other legal parent is determined to be unfit to care for your child, it is crucial that you choose someone who will care for your child and have it memorialized the right way. Everything has to be written out exactly how you want it. So the list that you have to do is to have a will. A will is the only place where you can nominate a guardian for your children in case of your death. If the preference for your guardian is not in a will, the court will no choice other than whoever applies by petition to the court. The court is guided by statutes, but several people may be in line and have the same level of priority. If two or more petition the court, family disunity will result for sure, and the children will become a volleyball in the middle. For instance, how does the court determines whose parents are more fit to care for your child? Yours, fathers or mothers, or parents, just parents, we're gonna say now. Whose parents are more fit? It is almost an impossible choice. It calls for Solomon's decision here. The will also directs the court as to how the assets to be used on behalf of the minor children and guardians. Generally, this is applicable only while children are under the age of majority. And as we mentioned before, we don't want our child to receive everything at the age of 18. They're not fit for that. It's just not right for us, and it's not right for them. They're not ready for this type of responsibility, even smart ones, even the most responsible ones. They just do not need that. So in a will, you can say that they can receive their inheritance at an older age. But again, it is subject to court's decision, and courts will have to supervise each and every penny spent. And it's not the best option, neither for you nor for your child, because if court is involved, then all these procedures are not free. They will be paid from the inheritance that is ultimately was designed for your child to have and use. Then, aside from your incapacity, you can also temporarily give a trusted individual the ability to make decisions for your minor child. This delegation is for a limited period of time, usually 6 months to 1 year. This document can be very helpful in the event that you're planning to leave your minor child in someone else's care while you're out of town for vacation or for business trip. Also, if you know that you're heading for surgery with longer recovery period needed. This ensures that if your child needs medical treatment or permission slip signed, someone will be able to handle those matters while you're gone or not able to make those decisions. And often people ask, how do we choose this temporary guardian? And so it has to be very thoughtful decision, not less than choosing guardian for long-term care. Usually it's a person that you know and your child knows, so they have the least amount of stress. It could be a neighbor, it could be a church member, or parents of their sports teammates, and somebody in proximity to your house. Also, you will have to make sure that you name the alternates there, just in case if that person is unable or can't or just doesn't want to take care of your child. This form has to be prepared, executed, and readily available at your house, at the daycare facility, at school, in the glove compartment of your car, because should accident happen, where the child will go. If, let's say you're alive and you had to be transported to the hospital, who will pick up the child? People say it's mother, father, grandfather, grandmother, sister, cousin, you name it. You trust them, you're unconscious. Police officers don't know these people. They cannot trust child, so they will have to give child protective services to care for the child until the whole situation is resolved. Whereas if in your glove compartment you have this short-term guardianship form, they will read it, notarized, sign. They will have the right to give child to the named individual. By the way, a little a little gift here. For those who participated today at this meeting, we will provide a courtesy copy of this short form guardian form. And please send us a request. You can type in a chat that, hey, I want this form, but we'll send it to you in any event. All right, so very important. So we talked today very briefly, believe me, there's so many more issues to go through, but I brought up the main reasons why we have to plan for your incapacity, for your death. We never know when life strikes and what's going to happen. Now you have a choice. You've already learned a lot today, and the question is, what will you do with it? As the English philosopher Herbert Spencer said, the great aim of education is not knowledge, but action. Will you click away from this training and telling yourself, oh yeah, it's important, and I will get around estate planning someday, right? If so, chances are you will be among those who procrastinate and never do anything until it's unfortunately too late. Or you will decide that now is your time. You will step up now for yourself, for your children, for those who depend on you, and for everyone you love. Today is the best chance to finally get this done. If that's you, you're committed on doing your best and making plans that you can trust, then here's how I can help. I've set aside some time in my calendar in the next few days to speak with you personally about your particular situation and possible solution. Remember, each family is different. I don't know if if you're a single mom with bank account and 2 children, or you have multi-million-dollar estate. So each and every situation is going to be different, and each situation requires different type of planning and different type of documents produced. So I've set aside time again to personally discuss your situation. And the cost of this call, it's absolutely free. And I will personally call you. And on this call, you will help me understand your biggest concerns right now, the important people in your life, your property situation, and the plans that you hope to make to protect everyone that you love and everything that you have. And if I think that I can help you to achieve your goals, I'll tell you so, and outline the exact next steps, what's going to happen. And you probably wonder how much such plan may cost. But as I said before, plans are so different and they vary. And I serve all my clients, single moms and millionaires. I don't care. I want everybody be protected. So I do not discriminate on your estate. I will help all of you if I can, of course. If I can't, I will tell you up front that I can't. But what I can guarantee is that if you decide to hire me, you will know exactly how much you're going to pay. There is going to be no hidden costs or fees. That's how I'd like to be treated myself, and that's how I treat my clients. So you'll know exactly what you're getting into. But in any event, you would receive your personalized plan and possibilities that you can achieve and kinds of protection that you and your family and your children may have. But this call is not for everyone. I don't want to just waste my time and your time. The people who I'm going to talk to must recognize that they have an estate planning problem, and that if things stand now, their children and family are not protected. And the most importantly, these people want to be able to solve the problem. And that you're done procrastinating, and you're ready to take an action and proceed to protecting your family and having peace of mind. And why am I offering this? I'm offering this because I'm standing against the machine. Being born and raised in Soviet Union, I'm so against the government interference in your life. I think that you are responsible for your life, for lives of your children, and for the future. So, and these machines, the government, they don't care about people. They just move cases, and not that fast, unfortunately. So I want to help you guard your affairs without any interference from government or other entities. And I believe people deserve dignity and have their lives legacy protected from the system. I believe in education because very few people know about all of these nuances, all the possible solutions and types of protection available to them. Unfortunately, only quote unquote rich people with their attorney's offices behind their backs all have all these solutions. And as you know, it's not always considering Larry King, but I want to bring these possibilities to middle-class people or regular people like single moms, just a regular worker, employee at the Starbucks. Everybody deserves the chance to protect whatever they have in their own. And I'm very passionate about providing people with all the tools possible to ensure they make their decisions about their lives, about the lives of their children, their assets, and not somebody else. I don't want the court clerk to put a coffee mug on your file and make decision sometime. So here's the information. There's the phone number, my address, email address, and website. So you can call, you can email us, you can go to the website, and on the upper right corner of the website, there is a Calendly link, and you can schedule a consultation yourself if you don't want to call us, all right? But in any event, we will call you sometime, we will contact you sometime, because I know that as soon as you click away, the life will carry you away again, and you may forget. It will go to the back of your mind, but you'll forget to schedule a call. So I will just call and ask, hey, are you interested or not? And that's it. I will not bug you, believe me. And while you have a chance to write down the information, I just wanted to share something with you. My practice is a mixture of emotions. When we create the plan for the family and they sign the documents, execute final documents, everyone's so happy. And the weight of thoughts and uncertainties is lifted from their shoulders. Even facial expressions change. They achieve peace of mind. But as we know, life can happen to us unexpectedly and strike at any time. When I receive a call from my clients or their family about client's disability or death, of course, there's sadness and mourning. However, at the same time, there's certainty, confidence in the future, understanding what's going to happen during this difficult time, and family isn't torn apart. Everyone knows exactly what has to be done and what will happen in the future. That is power. Legacy is preserved, families keep united, and they only have to concentrate on what is important in these difficult times. It's their family. I just love my job. Thank you so much for participating, ladies and gentlemen. I appreciate it. And again, there's so much more to discuss. I just didn't want to keep you for longer. If you have any specific questions, please give me a call. By the way, I wanted to say, if you have any questions, you can unmute and ask me questions. And there, I see there is chat. Okay. Okay, so I assume no questions. Jessica, Jess, anybody else? That's those who I see. All right, if there are no more questions, I'll close this presentation, and we'll be happy to hear from you soon. Thank you so much. Bye.